Good morning, everyone. My name is Harvinder Makar, and I would like to introduce our Associate General Counsel, our legal consultant, Christy Lovett, who will be doing the training today for everyone on VAWA, that is Violence Against Women's Act, Fair Housing, and Language Access Plan. Am I missing anything else, Christy? You're on mute. You're on mute, Christy.
Okay, sorry about that. No, today we're covering Violence Against Women's Act, VAWA, and the Language Access Plan.
Yes, and these are required by HUD for our HOPWA program, along with the other HUD programs. So this training is specifically for all of our HOPWA sponsors today. Please make a note that these are all required, and please have this updated again in your policies and procedure as well. Not taking any more time, I would now have Christy Lovett to do the training.
Good morning, everyone. Again, my name is Christy Lovett. I am part of the General Counsel department here at DCA. I am an Associate General Counsel assigned to the Housing Assistance Division, which contains most of our homeless programs as well as HOPWA. I also assist with the Housing Choice Voucher Program and our Fair Housing. So starting off, we're going to cover the Violence Against Women's Act. And in talking about the Violence Against Women's Act, the current definition of what is VAWA, it is violence. It's a federal law that affords protections to victims of domestic violence, dating violence, sexual assault, and stalking, regardless of sex, sexual orientation, or their gender identity. Even though women is in the title, I do like to always make note of this, that it does not apply only to women. Again, regardless of sex, sexual orientation, or gender identity. It also needs to be noted that currently the rules and regulations, HUD's rules and regulations as it applies to VAWA, are currently being amended. In 2022, VAWA was reauthorized and amended. It was, I believe the date was March 15th, 2022. The new amendments have strengthened the protections as it applies to VAWA and extended them. The majority of the protections became effective October 1st of 2022. And HUD is currently, again, updating the rules and regulations. So what's new? What's very important for you to be aware of are revisions to the definition for domestic violence, as well as the addition of two new definitions for economic abuse and technological abuse. In short, I will be providing, this PowerPoint will be available to you, and the full definitions are in the notes, and so you'll be able to read them. But in short, domestic violence includes felony or misdemeanor crimes committed by a current or former spouse or an intimate partner of the victim. And in the case of victim services, includes the use of attempted use of physical abuse or sexual abuse. Is when this abuse is used to gain or maintain power and control over a victim, including verbal, psychological, economic, or technological abuse. Perpetrators, people who commit these crimes, could be the current or former spouse or intimate partner of the victim, someone who is cohabiting or has cohabited with the victim, someone who shares a child in common with the victim, or an individual who commits acts against youth or adult victims who are protected under these laws. The new economic abuse definition is used in the context of domestic violence, means behavior that is coercive, deceptive, or unreasonably controls or restrains a person's ability to acquire, use, or maintain economic resources. This could include coercion, fraud, or manipulation to restrict a person's access, to unfairly use a person's personal economic resources, or to exert undue influence over that person's financial and economic behavior or their decisions. For technological abuse, and again, I'm going to give you the full definitions as part of this PowerPoint. Term for technological abuse means an act or pattern of behavior that is intended to harm, threaten, intimidate, control, stalk, harass, impersonate, exploit, extort, or monitor, except as otherwise permitted by law, another person using any form of technology, known or being currently developed. Additional updates under VAWA 22 include enforced compliance review processes, which HUD is currently developing and must be implemented. They must implement it by March 15, 2024, which will include more additional monitoring that we will have to conduct ourselves as an agency of our subgrantees. Prohibition on retaliation, and that could include those who assist the victim in reporting or anyone who reports a violation of VAWA. And then the right to report crime and emergencies for victims. So there are and there have been instances where there are properties that penalize tenants who report or have frequent reports of criminal activity. Tenants are now being given that right to report. There should be no retaliation against them for reporting crime or any other type of emergency that may happen at their units. Sorry. So a VAWA applies to anyone receiving federal funding, be that ESG, HOPWA, or other housing programs. They must adhere to VAWA regulations and contractual requirements with their grantor. And this goes, once again, to almost all, the HUD programs that are subject to this have been expanded under VAWA 2022. So HOPWA program that VAWA applies to includes acquisition, rehabilitation, conversion of new construction, operating costs, project and tenant-based rental assistance, and community residences. HOPWA short-term housing, although the majority of our protections apply to rental assistance, HOPWA regulations prohibit HOPWA short-term supported housing from refusing to provide assistance to or removing an individual on the basis of or as a direct result of their being a victim. Please note, no matter what programs you offer, it is always good to understand what protections are out there that your client may be able to utilize or may need. You may need to help your client or former client identify your tenants, identify that a right has been violated in any particular situation. So again, who is protected by VAWA? Those who are protected would include applicants as well as current program participants. So how would this come up? So you know that you have an applicant for a housing assistance or a current participant. How would you become aware that this person could be protected under VAWA? The applicant or the tenant has the responsibility to inform you. They need to inform property owner, manager of their victim status, and provide enough information for a property owner or manager to determine whether the adverse factor is a direct result from the fact that they are a victim, or if they need if you need extra information, you have to ask it in accordance with your policy. So you're going to have to properties need to implement policies. Providers need to implement policies. And these policies cannot have must have strict confidentiality rules affixed to them, and you must comply with that. If you need additional information or there's not enough information provided, uh, you may notify the tenant of such, but it has to fit within certain rules and guidelines. If you make a determination that any denial or eviction or termination of services needs to proceed because it's not associated the with any protections under VAWA, you must notify that victim or that individual in person. You must also put it in writing. Make sure you document everything that you do. Applicants for housing assistance. They cannot be denied admission or assistance based on factors, again, resulting from their victim status. Some of these examples include possible negative credit, rental history, criminal records. On the surface, adverse factors may appear unrelated to domestic violence, dating violence, sexual assault, or stalking. And they may appear that they present legitimate reasons for denial, termination, or eviction. However, adverse factors may directly result from an underlying domestic violence experience. It may be present during much of an abusive relationship, or it may present itself only when the victim is attempting to leave the abuse. For example, when we talk about negative credit, rental history, criminal records. For poor credit history, depending on the circumstances, poor credit history may be a direct result of an individual's victim status, such as being forced to obtain a credit card for the abuser using the victim's credit card without permission, possibly the abuser selling the victim's personal information or preventing the victim from obtaining employment, where they place utilities or other bills that go delinquent in the victim's name, or they have unpaid medical bills from the abuse. For poor rental history, examples could be property damage that has taken place from the abuse, noise complaints, any other types of criminal activity related to the abuse, or a history of lease terminations from being forced to move. Example of criminal records could include the abuser forcing the victim to write bad checks, creating, forcing the victim to steal, having a record of theft, or disorderly conduct. Note that if the negative factors above resulted from a situation in which the applicant was the victim of domestic violence, they cannot be denied assistance. So any of those examples that can be directly associated back to the victimization cannot be used to deny existence. There is an exception, and the exception circulates around if the denial is required by statute. For example, if they're subject to lifetime sex offender registration, then that would uh, that would overlie the VAWA protection. For VAWA and current participants, you cannot terminate or evict a victim merely because they are a victim or for those adverse factors that we have talked about. For criminal activity directly relating to the abuse, if the criminal activity committed is by a household member or guest, or and the victim is a tenant or guest, or for any actual or threatened DV incident. So now, actual and imminent threat, we must have objective evidence of words, gestures, actions, or other indicators that show a physical danger that is real or that danger would occur within an immediate time frame and that it could result in death or serious bodily harm. In determining whether an individual will pose an actual and imminent threat, there are 4 factors that you have to consider. First, the duration of the risk. Second, the nature and severity of the potential harm. Third, the likelihood that the potential harm will occur. And 4, the length of time before the potential harm would occur. So duration, nature and severity, likelihood, and then the length of time before action would happen. Note that there must be no other actions or remedies to reduce or eliminate the threat, including when those action or remedies are unavailable. HUD does encourage programs and properties to work with local law enforcement to prevent or remedy any instances where a threat may occur. Sorry, keep scrolling ahead. Can you still terminate or evict? You can for a violation, and this is very important. VAWA does have a lot of protections in place, and it may seem very strict and stringent, but you can still terminate or evict for a violation that's not related to a domestic violence act. Or, again, talking about actual and imminent threat, when there is an actual and imminent threat that cannot be remedied, specifically to the tenant or other tenants, or those who are employed or working at the property. You should consider the following actions if you are facing an actual or imminent threat to hopefully try and reduce the need to terminate. Some things that you can try, if these work, would be barring the perpetrator from the property, possibly changing the victim's locks if it was a former tenant or someone who has access, installing basic security features such as better lighting or an alarm system, encouraging the victim to seek an emergency transfer, allowing an early lease termination, allowing the victim to arrange for temporary absence from the assisted unit, or helping the victim access available services and support such as victim service providers or civil legal assistance providers, and working with the police again and victim service providers to help develop a safety plan for the property and a plan of action for the victim. So how do you verify the victim status? Again, uh, it is the responsibility and duty of the victim to inform the provider, the properties, that they have this status. But if you require written documentation to verify, there are several forms that you can use. One is the certification form that is available on HUD's website. If the victim has provided the certification form, you cannot ask for any supporting documentation. If the victim has not provided the form itself, but has provided third-party documentation, such as police reports, medical reports, those you can and have to accept as well. If the victim, again at the property's discretion, beyond those two forms, you can develop policies that or forms that you would be willing to accept as well as evidence. Again, if they provide the HUD form, you have to accept the HUD form and you cannot request additional information. But as with all of the rules, there are always exceptions, such as if you have a discrepancy between two tenants as to who the true victim is. Then you can ask for supporting documentation to help you identify which is the true victim versus which is the perpetrator. So other protections that are allowed would be lease bifurcation, which means you split the lease to evict the perpetrator while allowing the victim to remain, other family members to remain at the property. Note that when you do a lease separation where you're splitting the lease, the remaining family members must be still eligible for the program. VAWA does not trump program requirements, and in most cases, you can give a remaining family member 90 days or until the lease expires to establish eligibility or find other housing. Note again that you can terminate the lease of any resident or lawful occupant who engages in criminal acts of physical violence against their family members or others without terminating that assistance to or otherwise penalizing the victims. Emergency transfers. You can do a transfer to a safe unit. In those cases, you must have a written emergency transfer plan in place. Note that safe is determined by the tenant, not by what you would consider to be safe, but by what the victim would consider to be safe for them and their family members. The tenant must ask to be transferred, and the tenant must believe that there is a risk of imminent harm, or the tenant or household member must have been a victim on the premises within 90 days of the transfer request. Some best practices for an external move: make available list of similar housing in the area, or possibly make arrangement with other properties if you know of other properties to help facilitate the move. You could conduct outreach to DV or domestic violence organizations to see if they could assist you. possibly assist the victim with admissions preferences for any type of transfer to possibly another property you own that is owned, or provide a letter for the victim that they can use at other properties to assist with their emergency transfer. Notice requirements. All providers, our applicants and tenants are required to provide notice. Applicants and tenants must receive a notice of occupancy rights that explains the VAWA protections and limitations, as well as certification form. That one, again, that's the form that must be accepted if a victim reports that they have that status, protective status, where the victim can document an incidence of violence, dating violence, sexual assault, or stalking. I provided an active link here, but please note that HUD, again, is currently amending these forms. So if you do utilize the forms, please try to stay up to date on any amendments, and we'll try to ensure that we notify you once they have been posted. So the HUD Form 5380 is the notice form, and the HUD Form 5382 is the certification form. There are two additional forms that are available through this link. That would be HUD, that relate to VAWA, that would be HUD 5381, which is the Model Emergency Transfer Plan. And then if there would be HUD 5383, which is the Emergency Transfer Request. When providing these forms, you should do your best to ensure that all members of a household have received them, and not just the head of household or the participant within the program. Because it could be that that head of household is the perpetrator. Sorry, my mouse is very, very sensitive today. In issuing that notice of occupancy rights, that form allows you to insert information about your program into the form. Note that you should not make any changes to the core protections and confidentiality rights that are in the notice, but you should customize it to reflect the specific program or assistance that you are providing. So your language, any language that you add, as long as it does not change the core protections, should be made. So an example would be, you cannot add language that adds new conditions or requirements to receive our protections, but you can add additional language that may help a victim or reader better understand what protections there are that are available. I did want to add, let me go back. I did want to add that these forms are available. HUD has provided these forms in several languages. So when do you give the documents? They must be provided at specific times, generally at the time that an applicant is denied rental assistance or admission, and at the time an individual begins to receive rental assistance or is admitted to a project-based unit. When a notification of eviction from an assisted unit is received, or the program terminates rental assistance. Anytime that you provide documentation, especially considering the fact that we now will be under stricter monitoring, you should document and keep note of the fact that you have provided these documents. For HOPWA, project sponsors must give the forms as well as the housing owner or manager. Very important when you're dealing with victims of abuse is confidentiality and access. You must keep any information you receive confidential for their safety and protection. You cannot enter the information into a shared database. Uh, you must maintain confidential record keeping, even if that includes maintaining these records separate from the remainder of your files. You can Employees who do not work directly with the victim should not have access to the victim's information. You really need to think through how you will communicate with the victim, especially if at the time that you become aware the abuser still lives in the home with the victim. Do not call, do not mail notices, do not just stop by and drop off. You must discuss personal information with that victim in person in a private setting to ensure that no one else is around. When you are developing your policies, once again, make sure that you do include specific rules and regulations, rules and policies, of regarding how you are going to maintain confidentiality and how you will communicate with any victims. Additional resources that are available are listed on this screenshot here. Again, this PowerPoint will be provided to you. Before moving on, I did want to state that this concludes our presentation on VAWA, our training on VAWA. If you have any questions, please drop them, note them in the comment section. We will try and leave time at the end to go through your questions and ensure that they're all addressed. At this time, we're going to take a shift from VAWA and review, because hopefully this is a review from the majority of you. There may be some new providers, but to review our language access plan and services that we must provide to limited English proficient or LEP persons. So, who are limited English proficient persons? They are persons who either do not speak English as their primary language as a result of their national origin, or who have a limited ability to speak, read, write, or understand English. LEP obligations apply to every LEP person who meets the program requirements, regardless of their citizenship status. So, what is the goal? The goal is to ensure that any individual who qualifies as LEP has an equal opportunity to participate in and benefit from the program. We want to ensure that they have the same range of choices as those offered to non-LEP individuals. DCA has translated most of their forms. especially the HMIS forms, into the 4 languages that DCA is required to translate our forms into. And those 4 languages include Spanish, Vietnamese, Korean, and then Chinese. So, how do you meet the goal? HUD requires recipients of federal assistance to appoint an LEP coordinator, to create a language access plan or 4-factor analysis, to conduct outreach, and to determine what services you provide or will provide that will require translation of vital documents, meaning those documents that an individual has to have in order to participate in, to know about the program and to participate in the program. And then to offer interpretation when communicating with any individual who is an applicant or participant in your program. I will state that I am the LEP coordinator here at DCA. Conducting the 4-factor analysis. When In order to actually provide these services, you must have a language access plan in place. A language access plan, DCA's language access plan is reviewed and updated every 5 years. We just completed our 5-year review and update in 2022. You'll see later on there's a link to the plan available through this PowerPoint presentation. But the language access plan, everyone must submit a copy of your language access plan to DCA so that we will have it on file. If you have questions or require assistance in developing one, please let us know. We do have, you can use DCA's plan as a template to help you build your own. If you are one of our existing providers who have been around for a while, you should have your plan in place. Please check it and confirm that it is still valid. Make sure that if it is time for you to renew or update, that you do so, and that you ensure that DCA has a copy of your most recent plan on file. The plan should be based off of you having conducted a 4-factor analysis. So the 4-factor analysis includes the number of LEP persons, which is factor 1. This determines the level of translation interpretation needed. So what is the number and percent of LEP people in your activity area? A DCA we do offer a mapping tool that I must inform you is not as up to date as it was previously because it's based off of US Census data. And this time around, the US Census did not get as detailed into the state of Georgia as it has done previously, where it was down to the local areas. For whatever reason, it is based on county level information. It does not, and the county level information even itself is limited. But US providers in your area are probably have greater knowledge of what the need is in your communities than we would as a state agency. So use the tool if you can. There is dated information that is very local and specific, and we'll get down into those more local areas, but realize it is dated and communities can shift in the 10-year time period that this data is accumulated. Factor 2 talks about frequency of interaction. So, how often would an LEP person come into contact with your project or any activity that is taking place? Is it daily, weekly, or monthly? Or would it be annually? For instance, daily walk ins or yearly public hearings. Factor 3 is the nature and importance of the activity. So, what is the activity that is taking place? How important is it that you be able to communicate with any individual? Would a denial or a delay of access to the services or information be serious or life threatening? Examples would be an eviction notice would be highly important, while a recreational program would be less important. Important, but less important than an eviction or termination. And then the fourth factor covers resources that are available. So you should translate. And so this talks about actual translation and what documents you have that are you've translated, what vital documents you have that should be translated, such as public notices, flyers, applications for assistance, having bilingual staff available, or what tools will you use if you do not have bilingual staff available? How will you communicate with someone who calls in who may be hearing impaired? Or having written translation community partners such as the I Speak cards. So your plan itself, again, will contain the four-factor analysis, um, ensuring that you have a responsible coordinator or staff member who is designated as your LEP coordinator or your individual who will assist with the language access, ensuring that you've created a training plan for staff and have that included in your plan, ensuring that's part of that four-factor analysis that you've identified the vital documents that are needed and translated them, and ensuring that when those forms are updated, that you set deadlines for translating them. You ensure that you've included a complaint and an appeal policy or process. Uh, Again, DCA has done that as well, and we have that listed. And you can see when you look through our files, you will see the plan. You'll also see what our complaint appeal process looks like. Then have you included when the lap will be updated. And once again, we recommend every 5 years. And if your plan has met that 5-year deadline, ensuring that you actually update it. So DCA cannot tell you again how you should comply with HUD's rules. We cannot tell you or show you. We can give you examples and we can assist, but we can't tell you what to do to satisfy your requirement. That's HUD's role. Okay. But once again, we can assist and provide some suggestions. So this is the link that will take you to DCA's language access plan as well as our complaint forms. And do note that we are responsible for monitoring your compliance with this. With that being stated, we have, I believe, 15 minutes remaining for any questions or concerns you would like to share or have.
So thank you, Christy. This is the time for everyone to ask any questions. Is that correct?
That's
Christy,
correct.
are you going to
That's correct.
are you going to touch base on fair housing?
That was not the goal for today. The goal was today was for VAWA and language access plan,
Okay.
but I can we can touch base real quick if you would like. I do not have a PowerPoint available for that, but I can give you a brief sorry. I can we can go through a brief review of fair housing if you would like.
Sure. If it is possible, or
It
if
is.
you,
Yes,
okay.
definitely. Definitely, definitely. Give me 1 second and while I make that shift. One second, please. Okay. Let me try this again. Okay, do you see the screen that says fair housing? Is that PowerPoint up and available to you?
Yes, we can see it, Christy.
You can see it where it says fair housing. Okay.
Yes.
Okay, good. So, fair housing, always ready and available to talk about fair housing. Fair housing, it is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. Uh, there are several civil rights statutes, and I will make this PowerPoint available as well. There are several civil rights statutes that go into and support the rights for fair housing. Some quick points about fair housing. It is the law. Compliance requirements to complete, and it includes compliance requirements to complete and provide language access plans to DCA, which we've already just discussed, to complete record keeping, provide reasonable accommodations, and there's a requirement to affirmatively further fair housing. Affirmatively further fair housing. I'm getting a little tongue-tied. So who's required to comply with the Fair Housing Act? All direct recipients of federal funds, all subrecipients, so those who operate programs that DCA provides assistance subgrants to, are also required to comply. What exactly does fair housing state? It states that there should be no discrimination against protected classes. Those protected classes include race, color, religion, national origin, sex, familial status, disability. A person has to fall within one of these protected classes to be able to allege a violation of the Fair Housing Act. Note that families do include one or more children under the age of 18 who live with a parent, a person who has legal custody of the child or children, or the designee of the parent or legal custodian with that parent or legal custodian's written permission. Familial status also includes pregnant women. Fair housing and equal opportunity ensure non-discriminatory treatment of individuals within one of those 7 protected classes, providing equal access to all programs, services, and activities that receive any of federal funds. Then again, affirmatively furthering fair housing, actively taking actions to further fair housing. For meaningful access, that the best practice is to ensure that persons within one of those protected classes have an equal opportunity to participate in and benefit from the program, any service or activity, and have the same range of choices as those offered to non-disabled individuals. Going back again, similar to those who are LEP, limited English proficient, ensuring that they have the same access to any of the program services or activities. So categories of prohibited practices. We have disparate treatment, which occurs when a protected class is treated in a less favorable manner. You have disparate impact, and then you have failure to provide reasonable accommodations or modifications. So the Fair Housing Act recognizes 2 types of discrimination. You have the discriminatory treatment where the victim is expressly treated differently than others in their community based on their protected class. And then you have discrimination through disparate impact, where that occurs when a neutral, what appears to be on the face a neutral rule or policy, actually has the effect of disproportionately affecting anyone who falls within those protected classes. So generally, when you have disparate impact, it is unintentional, but it may be unintentional, but it still places restrictions on a family. So disparate treatment is more blatant. You know that they're being abused. They're being hindered because of one of their protected classes. A disparate impact may be something along the lines of having a rule or policy in place where children have to be escorted throughout the property by an adult. Sorry again, really quick mouse. Examples of discrimination. So a refusal to sell, rent, or otherwise make unavailable or deny. Steering people toward or away from a particular neighborhood based upon one of the protected classes. Falsely telling someone that a unit is not available for sale or rent based upon a protected class, amongst other examples. Reasonable accommodations are required under Fair Housing Act. A reasonable accommodation is a change or an adaptation or modification to a policy, program, or service that is provided, including at the workplace, which will allow an otherwise qualified person who has a disability to participate fully in a program, take advantage of a service, or live in a dwelling or perform a job. So, in order to show that a requested accommodation is necessary, there must be an identifiable relationship or a nexus, a connection between the requested accommodation and that individual's disability. The request can be made by the person themselves or by a family member or someone else who is authorized to act on that individual's behalf. Sorry, again, sensitive mouse. Reasonable accommodations may be necessary at all housing stages, from the actual application itself, during the tenancy, and then also throughout an eviction that may take place. When a reasonable accommodation is requested, extra fees or deposits cannot be required as a condition of receiving that accommodation, with some exceptions. So, who qualifies as disabled? The definition of a person with a disability for purposes of granting a reasonable accommodation is different or broader than what the actual HUD definition of disability is. So you must take that into consideration. Any person who has or is regarded as having, one, a physical or mental impairment, that two, substantially limits one or more major life activities. Note that individuals in recovery from drug or alcohol abuse are also covered under the Fair Housing Act. However, individuals who are currently using illegal substances are not protected under the law unless they have a separate disability. Ordinarily, you cannot inquire as to the nature and severity of an individual's disability. However, in response to a request for a reasonable accommodation or a reasonable modification, if the disability is not obvious, you may request reliable disability-related information that is, one, necessary to verify that the person meets the Act's definition, two, describes the needed accommodation, and three, shows the relationship between the person's disability and the need for the requested accommodation. Please be careful not to delay someone's access to reasonable accommodation for unnecessary delays in requesting additional or supporting information. When making a reasonable accommodation, you want to look at whether or not that accommodation is reasonable. Note that you can only do this if you look at each individual case on its own basis. You have to look at it individually. You should do everything that you can to assist, but note you are not required to make changes that will fundamentally alter the program or create an undue financial and administrative burden. If you make a determination that the accommodation is not reasonable, do note that you should make a recommendation or provide an alternate or comparable accommodation that qualifies as reasonable. So examples of common reasonable accommodations would include allowing a service or therapy animal despite having a no pet policy in place. Sometimes it could be obvious when you have a blind individual who requests a support animal. Something that may not be something that's less obvious would be someone who requires an emotional support pet for a mental impairment. Note that the Fair Housing Act does not require an assistance animal to be formally trained or certified. And you cannot charge a pet deposit or prohibit certain types. of pets. We cannot make a decision as to what type of animal is considered a service or therapy pet. Other examples would be ensuring that the tenant has a live-in aid when needed, or assigning a reserved parking space. There have been several lawsuit examples of violations. Note that the majority do deal with assistance animals or parking spaces. Reasonable accommodations to explain tenancy behavior. You have to go through the whole process. Is there a disability and a connection? If so, would there be a fundamental alteration to the program? You never have to admit anyone who, one, poses a direct threat to others, or two, causes substantial damage to property of others. Can the person show how they can now comply with the lease uh, based upon that reasonable accommodation? Did something change, or is there a proposed plan to solve the issues? So when does this come in place? When a tenant may have a bad tenancy record, or as a result of a record of failure to take proper medication. If that tenant can provide evidence to the housing provider that he or she has made arrangements that ensure that the tenant will take the needed medication, such as daily nurse visits, the housing provider may need to waive any rules requiring rejection of the applicant. But you may want to ensure that there's some type of accommodation or some type of policy process in place. Reasonable modifications include circumstances such as a structural change made to the existing premise to afford a disabled person full enjoyment, or if like reasonable accommodations, a modification must be reasonable with the nexus between the modification and the request. So structural changes such as ramps or anything that where you are making a change to the actual building itself. See that we're running short on time, so but I do want to cover really quickly sexual harassment in housing. Sexual harassment is a form of sex discrimination prohibited by the Fair Housing Act. Claims may be filed even if the alleged victim did not experience loss of housing or economic loss. Two types of harassment. There's the quid pro quo harassment that occurs when a housing provider requires a person to submit an unwelcome request to exchange or engage in sexual conduct as a condition of obtaining or maintaining housing. And then the other would be the form of hostile environment, where circumstances surrounding activities make it very hostile to an individual. Best practices would include adopting policies against sexual harassment, developing processes for applicants and tenants to report, establishing sanctions, educating. Education is very important, and enforcing these policies. I'm going to end here with liability for violations. You can be directly liable for your own discriminatory acts or those of an employee or third party that you had the power to correct. Vicarious liability, where you are responsible for your employees, even if you did not know about the discrimination taking place. And to note that an aggrieved person has 1 year to file a HUD complaint. I know we rushed through fair housing very quickly, but if you have any questions, please note them down, or you can submit them through Harvinder's team or directly to me, and we'll try and address and assist you with that matter. Okay,
Thank you, Christy. This
you're
was
welcome.
very important and useful information. Again, we did record. I hope it is going on. And it is very important. As you know, the HOPWA program is for persons living with HIV/AIDS. That has a very high level of confidentiality that is as a requirement. And on top of that, today, what Christy Levitt had talked about, VAWA, Language Access Plan, and Fair Housing. So that those are also required by HUD for any federal grant, including HOPWA. And these are also part of your monitoring then when the HOPWA monitoring is conducted. So please make sure that you have the policies and procedures in place to cover all these. And we have provided the forms for VAWA to be used for all the clients to when you enroll them in the programs that they must complete, or whenever they request, at that time they need to be provided those forms as well. And with regard to the language access plan, we would like you to review your existing plan and submit the copy to us as part of your annual contract that we have now. The contracts would be going out. I would suggest, because Christy looked into the policy, agencies have 60 days to review and submit and update and submit your LAP plan to DCA. So with that said, I would say everybody must submit your LAP plans by January, in the beginning of the January. And we would send a separate email notifying that, or sending information on submission of your language access plan to us with that. Um, with that, we say, if there is any question, I do not see any question that has been submitted in the chat so far. Because of the time, we can say you can send us your questions or inquiries via emails and reach out to Ayana, Edie, or Michelle Carter, or myself, and we will get your responses from Christy Lovett for any of your cases that we will do. With that, we say thank you. Thank you, everyone, for participating today. And thank you, Christy Lovett, for very comprehensive training. And thanks for accommodating fair housing at the last minute.
No problem. Thank you.